MP Uteem. As the world of shopping celebrates Black Friday, today will go down in history as one of the darkest days for our democracy, for our constitutional right to freedom of speech. When a government, of which MMM was a party, brought the IBA Act in 2000, the main function of the radio in those days were to inform and entertain. But over the years, Mr. Speaker, sir, the role of private radios in Russia has completely changed. And today, private radios have become the main medium for the population to comment on public events and to air their grievances. Whether it is enquête en direct, explique ou cas, faire noir vin blanc, la voix Maurice, polémique, lever de moped. Private radios today, Mr. Speaker, sir, have become the bridge between the people and the authority, the main gateway to relay information, to comment on events, and to make complaints. And today, even now, if anybody turns on the radio, a private radio, any radio except for NBC and probably Reza Uteem, what will they hear? What are the people out there saying, Mr. Speaker, sir? Mauritius is safe. Mauritius is relatively safe. Everything is fine. Tout correct, tamam. Or are the people complaining and criticizing the government? Nurses, doctors, medical experts, experts in education, social workers, people admitted to ENT, people queuing up to get vaccinated, family of victims. Are they praising this government? Or are they criticizing the way the government is mishandling the COVID situation? So the purpose of this bill, let's not get any doubt about it. The purpose of this bill is to silence these complaints by removing the bridge, the gateway, the messenger. Yes, today we are shooting the messenger, the private radio. And we are doing it, and they are doing it because we don't agree with this bill. They have decided to do it by suffocating the radio financially. The IBA is being given the power to impose such administrative penalties as it thinks fit. And the administrative penalty would be as high as 500,000. The 500,000 is for one offense, one time. It can be more. And this administrative penalty is going to be imposed not only if, according to the IBA, a private radio has breached the act or the code or the condition of their license, which would be understandable, but also if they have failed to comply with any direction of the IBA. IBA has an absolute discretion to give whatever direction they want to a private radio, and if that private radio doesn't do it, 500,000 rupees fine. So if IBA is not happy with the way a radio has reported any information, or the press conference, however unreasonable IBA may be, he can order the radio to issue a communique, a rectification, and if the radio doesn't do that, 500,000 rupee penalty. If the IBA is not happy about people who come on the radio, make comments, and air their grievances, 500,000 rupees penalty. And I'm not exaggerating, Mr. Speaker, sir. I'm not exaggerating. The Honorable Leader of Opposition talked about Top FM. It is public knowledge that there is a case of judicial review which Top FM has brought against the IBA. I'm not going to, of course, deal on the merit of that case, which is sub judice, but I'll just in one line say what the case is about. The IBA was not happy that one day on Top FM, a trade unionist and former member of this House, Mr. Jack Bisdal, made certain comments. IBA was not happy about that. They thought that Top FM had breached its code of conduct and therefore decided to suspend the license of Top FM. And Top FM has now brought the case before the Supreme Court for judicial review. So the IBA is taking sanction against the radio not because of the fault of journalists, not because they have anything against the journalists, because they are not agreeable with people going on radio and airing their grievances, especially against this government. Now let me take a simple example, Mr. Speaker, sir, just by way of illustration. Tomorrow morning, a member of the public calls a private radio and says, yesterday I was listening to the live broadcast and the exchange that happened in the House between the Honourable Prime Minister and the Leader of Opposition, and I think that the Honourable Prime Minister misled the House. And I say so because at the time the committee, interparliamentary committees were hearing in 2016, 2017, the Honourable Prime Minister was not even part of that committee because he had had to resign since 1st July of 2015. And therefore, whatever he said happened there, he could not possibly have known because he was not there. He had resigned. IBA is not happy. IBA said, no, yesterday I heard the Prime Minister say what he said happened. And therefore, you, private radio, you have breached the code of conduct by allowing a member of public to bring that fact to the public so that the public know that the Honourable Prime Minister was not part of that committee because he had resigned office since 1st July 2015. 500,000 would be fine. 500,000 would be fine because the radio is not because IBA is not happy with that radio. But of course, when the radio will be fined, what will it do? It will have recourse to the Supreme Court. But we all know that a case before the Supreme Court can take months, if not years. What happened in the meantime? In the meantime, the normal course of things, the IBA's decision would be stayed pending the determination of the Supreme Court. This is elementary rule of fairness, rule of natural justice, a rule of a right of protection of the law guaranteed by Article 3A of our Constitution. Any lawyers know that. There is a decision, you're making an appeal, you ask for a stay of the decision. Stay, status quo, let the court decide. But the IBA doesn't agree. Government doesn't agree. The proposed new section 22, subsection 4, and I'll read it because it's very important. The authority may, notwithstanding any pending judicial process, take into account any sanction imposed by it on a licensee for the purpose of determining whether or not to renew a license. Notwithstanding any pending judicial process. I couldn't believe my eyes when I saw that. How can state law office allow such a provision to be included in this bill? How can the Attorney General, who is the advisor to government, accede to that bill in cabinet? I mean, the IBA is being given the power to disregard the Supreme Court. What happened in Supreme Court? Not our concern. Simply unbelievable. The IBA has become party, judge, jury, executioner. What is the point of giving the right of appeal to a licensee? What is the point of giving him the right to seek redress before the Supreme Court if the IBA will simply disregard pending judicial process? And what about the doctrine of separation of powers? Can Parliament simply legislate that an authority, which is not even an independent authority, can disregard pending judicial process? Isn't that a clear usurpation of the judicial function of the court? Shouldn't it be left to the court to decide whether to suspend an administrative decision pending the determination of the court? Worse, Mr. Speaker, sir. Section 22.5 provides that the IBA will consider past conduct of a licensee prior to determining whether or not to renew a license. And here the choice of words is very important. Section 22, subsection 5 uses the term shall, not the term may, shall. Parliament is directing IBA. IBA must consider past conduct of a licensee before determining whether to renew or not. Even if the case is pending before the case, he has to. And the Honourable Prime Minister very happily said, yes, this is how courts operate. Before sanctioning, before sentencing, the court takes past conduct. But Mr. Speaker, sir, IBA is not a court. This is the whole point. You are usurping the role of the court. This is a clear breach of separation of power. This is anti-constitutional. Now, the Honourable Leader of the Opposition referred to the period of the license. Today, a license for radio broadcasting is 3 years. It is being proposed in this bill to reduce that license for 1 year. And the justification given by the Prime Minister, or the Prime Minister, is that you pay fees annually, and therefore your license is renewed annually. Well, you pay lease for state land annually, but you have lease for 60 years. What's the logic? What's the logic? Because you have annual fees, therefore your license fees has to be annual? I've never heard that such type of logic. But 3 years is reduced to 1 year. Why? Because they know that the license of Top FM is due to expire end of this month, well, beginning mid of December, in a few days' time. That is why they've rushed this bill today. There is debates on petroleum bill, second reading, it's still pending, that's not important. What is important is get this bill through so that the IBA can get the power to not review the license for Top FM and disregard the case that is pending before the Supreme Court. And now, what would happen when the license is not renewed? What will happen to all these journalists who are working today at the radio? Will they be unemployed? Will certainly resign. Now, what would happen to the radio without any advertisement? Where will it get the funds? How will it be able to repay its loan? How will it be able to meet its financial commitments? It will go bankrupt. So by the time the judicial review is heard and determined and the decision of the IBA is overturned by the Supreme Court, there's nothing left. The radio is already bankrupt. So this is how dangerous this bill is which is being brought before this House. And the Honourable Leader of the Opposition is absolutely right. This bill is targeting one private radio, in particular, Top FM. And there is a doctrine, or a dictum in law, Mr. Speaker, sir, which is Latin, which is called ad hominem. This law is what we call an ad hominem law. Hominem in Latin means to the person. So this law is directed to one person. Is that constitutional? There are many cases, Privy Council cases, on ad hominem laws. But when they are targeting Top FM, there are spillover effects, because the same law will apply to all radios now. 2 years ago, in the Finance Act 2019, Section 19 of the IBA Act was amended to increase the percentage shares owned by foreign nationals in radio and TV broadcasting companies to 49.9%. Who presented the bill? The Minister of Finance, who was no one else than the Prime Minister, our current Prime Minister. And when he introduced this bill, this amendment, what did he say? The amendment was necessary to attract more foreign investment in telecommunication and media sector, while providing better services and choices to the Mauritian customer. 2 years ago, he amends the law to provide better services and choice to the Mauritian customer. 2 years later, he does the reverse. Because surely, who in his which right-minded investor is going to invest millions of rupees in equipment in a radio station or a TV station if his license would not be renewed after 1 year? So it simply doesn't make economic sense. But it sure makes political sense. It makes political sense. The license of a radio is limited to one year. Why? To make sure that those independent radios that dare to criticize the government will not be able to broadcast during the electoral campaign. This is the ultimate aim of the bill: silence the voice of critics before and during general elections. I mentioned general election because this is what happened during the last general election. This bill targets only private radios. It doesn't target Mauritius Broadcasting Corporation. The NBC is not concerned at all. Today, the NBC have a license of 5 years. Has a license of 5 years. The amendment doesn't concern NBC. He will continue to pay 5 years, even if NBC has annual fees to pay. But then for NBC, it doesn't matter. You know, only for private radios that you have to change every year. NBC, you can leave it for 5 years. Why? Because IBA is happy with NBC. Prime Minister is happy with NBC. And no matter how much we complain about NBC, no matter how much we write to IBA, IBA never sanctions NBC. During the election campaign of 2019, everybody saw how biased the NBC TV was. The president of the Labour Party complained to the Electoral Supervisory Commission about the unfair treatment by the NBC of its reporting of the general election. On 29th October 2019, the Electoral Supervisory Commission issued a communiqué after hearing the NBC and its counsel. What did the communiqué say? The Commission, after deliberation, reached the conclusion that prima facie there was substance in the complaint made having regard to Section 4G3 of the NBC Act. The Electoral Supervisory Commission blames NBC TV, who is acting in violation of the NBC Act. Did IBA take any sanction against NBC? Did it suspend the NBC? No, because the NBC is doing what the IBA is happy and wants private radio also to follow leads. Mr. Chairman, Mr. Speaker, sir, the bill introduces a new mechanism for reviewing the decision of the IBA. The bill is getting away with striking out the provision relating to complaints committee. So now we will have a review panel, an independent broadcasting review panel, which is going to review the decision of the IBA. The Honourable Prime Minister is right when he said that this independent broadcasting review panel, the provisions, are similar to what is in the Bank of Mauritius Act and in the Financial Services Act, but not totally correct. Will start on membership. The membership of the committee for the independent broadcasting review panel, there will be a chairman who will be a barrister of at least 15 years, 5 years. Then there will be 2 members having wide experience in the field of broadcasting. And these 2 persons will be political appointees. It doesn't have to have any restriction on their political color. Now compare that to the membership of the Financial Services Review Panel. Services Review Panel, you have a chairperson who is a barrister of 5 years standing, but you have a vice chairperson who is either the Solicitor General or his representative. And the 3rd member is the Financial Secretary or his representatives. So the composition is completely different. One, you have very independent members, and the other one, you have political appointees. And where it gets worse is under this bill. The quorum for this review panel is 2 members. 2 members, so you don't need to have the chairman. You don't need to have a lawyer. 2 political nominees can sit and hear appeals. And can you imagine how dangerous this would be? At least for the review panel for the financial services, there's always a lawyer, either the chairperson or the vice chairperson, who is the Solicitor General. Now, the next thing is the termination of the tenure of the chairperson. It's the same in the Financial Services Act, and it's flawed. So I think that it has to change in both laws. The law that is being proposed today will provide that it's in section 30B, the chairperson of the review panel shall cease to hold office where he is unfit to be the chairperson because of breach of trust, misconduct, or default in the discharge of his duties. Who decides? Who removes the chairperson? Is it IBA? Is it the Prime Minister? Surely it must be a court. Who decides that he is unfit? Is it the IBA? Is it the Prime Minister? Should be a court. Who decides what is breach of trust? Breach of trust is there only in fiduciary duties. What is meant by breach of trust? The Prime Minister no longer has trust in the chairman. The IBA no longer have trust in the chairman. What is breach of trust? So that is why I think the Prime Minister ought to come with an amendment, at least specifying that it is only a court of law that can determine whether a chairperson is unfit or not. Mr. Speaker, sir, the credibility of the review panel and its impartiality will very much depend on the person who is appointed as chairperson. The current chairperson of the Financial Services Review Panel is a former judge, Mr. Gérard Angot, whose professionalism and impartiality is beyond dispute. The current chairperson of the Complaints Committee of the IBA, which will be replaced by the review panel, is Mr. Gilbert Itier, Senior Counsel, a senior lawyer whose professionalism and impartiality is beyond dispute. Will the Prime Minister, Honourable Prime Minister, give assurance to the House that Mr. Gilbert Itier, who is currently the chairman of that Complaints Committee, would be appointed chairperson of the Independent Broadcasting Review Panel? If not, why not? And if the Honourable Prime Minister is not minded to appoint Mr. Gilbert Itier as chairperson, will he give assurance to the House that the chairperson would either be a former judge or a senior counsel, of course a senior counsel, who has never appeared for him or any member of his party as counsel? If not, then the population will surely judge him on his action. Mr. Speaker, sir, this bill comes a week after the cybersecurity and cybercrime bill, and the timing is not innocent. Behind the facade of self-denial, the government knows how unpopular it has become, and they know that the worst is yet to come. But trying to silence criticism published on the internet or air in radio is futile. Mr. Speaker, sir, if this government doesn't want to be criticized, then arrête faner, or better still, lève paquet aller. Thank you.